law, that is a de novo standard of review, because that means the court got it wrong. But I'm going to show you guys how Honorable Victoria Wood, she didn't just ignore the statutory language of the law, she rewrote the language of the law, which some would say is legislating from the bench. Judges are not allowed to write the law as they see fit from the bench. That's Congress. Congress writes the law. Legislators write the law, not judges. Judges are to read it, translate it, copy and paste, get it done. The court shall do X, Y, and Z, must. The judges then must do that. Honorable Victoria Wood did not do that. She rewrote Family Code 2030, her own version of it that was judicially biased towards me. And it was catastrophic because the expectation, what she did is in defiance of exactly why Family Code 2030 Pendente Lite exists. It's meant to remove parity, to remove disparity and create parity in dissolutions or marital separations. So I want to read this. This is her version of Family Code 2030. Mr. Anaya's request for needs-based attorney's fees is denied at this time on the basis that Miss such and such does not have adequate funds or access to funds to pay for said fees. Now, I have the evidence which has been submitted to the Supreme Court and to the Court of Appeals. It was in my appellate brief, the evidence and it was in the request for Pendente Lite, that there was $22,000 just sitting there in an account. But what Honorable Victoria Wood did was she didn't want her to have to pull from that money. And that's not Victoria Wood's ability to do so. It's a must and a shall. So she had the ability to order her to pull from that and give her, there's like something they can sign that gives you to not be penalized. So that is a 100% false predicated narrative right there. That's a false predicate, that the money wasn't available. It was right there in front of her, and I can show you guys that. So when the First District Court of Appeals said that this was properly addressed, so they were trying to give themselves the reason to say this is abuse, this isn't abuse of discretion, or that. No, they were trying to time bar Family Code 2030 and say, oh no, we don't know, because it is a de novo standard. If you're denied needs-based attorney's fees and then they slam you, you appeal it, it's supposed to be reversed. And that's in remarriage of Knox 2022. So once the home is sold and the proceeds are distributed to the joint account, not Gregory Winter's IOTA, his personal account, which he then changed it later when she left and a new judge came in. Gregory Winter and his client had the judge change that, which violates stare decisis, which they're not supposed to change Victoria Wood's ruling. Mr. Anaya may renew his request, or the parties may stipulate outside of court for him to receive a distribution of the sale of the proceeds for attorney's fees with jurisdiction likely to be reserved as to allocation of the source of those funds. In other words, should the parties stipulate to one or both sides receiving a preliminary distribution of home sale proceeds to pay for attorney's fees, any dispute as to which party should ultimately be charged for said distribution will be reserved until trial. She wrote her own law right there. There's nothing in none of this stuff is in Family Code 2030. She flat out violated my rights. She said that there was no money when there was $22,000 sitting right there in front of her in the documentation. That's a 100% false predicate. So she violated Family Code 2030 right there on the dot. Then she gave all this other stuff. Did you hear what she said? Oh, parties may stipulate outside of the court and all this. Man, they're not going to stipulate to giving me monies from those things. They're going to be difficult because they want to make sure that the deck is slanted against me. So I'm stuck having to do all this stuff without an attorney against a paid professional attorney and a county employee for the county of Napa who works for Child Welfare Services. But not just any CPS worker, but a CPS worker who has a criminal history that led to the loss of her parental rights as a result. So they have something to hide. The judges in Napa, the county of Napa, the child welfare services. Imagine an officer or a judge that's hired and sent all kinds of people to the Bing, and then all of a sudden it comes out like, oh yeah, we found out that one of our peers here has a significant criminal record that conflicts with everything that we do here on the bench or on the force or anything else. So then that's a huge liability. And that's why Napa County has made sure that they've exercised they're using every bit of energy and strength that they have. Whether or not they put my son in harm's way, they could care less. Because Victoria Wood, when I asked her to put SoberLink in place, when part of that criminal history that cost those parental rights was bebiendo y corriendo, right? Los dos. A judge, Justice Julia Coletti, determined that that person was a danger to their child because of said behavior. And the court, and I said, hey, I'd like SoberLink in place, man. That behavior, I have the proof, the photos, everything. And they were just like, no, because they can't put that against a CPS worker because that could get out. That means the person's no longer effective. Because how would it be if a CPS worker had an order that prohibited them from doing things that CPS workers ain't? How could a CPS worker be out taking people's children, yet they're over here doing the same conduct? So the court laid down cover and camouflage and concealment. They didn't care about what harm it would do to my son. As a matter of fact, they did nothing but make excuses. So to deny SoberLink with all of this stuff in place, that's a reasonable request. The new judge, Robert Stamps, he's just picked up the torch and he's running with it. But imagine if one of them, if their spouse, and I've said that to them, imagine if it was your spouse putting your child in harm's way. What duty do you have? See, they have children and they know what the duty as a parent is. But I look to them and I say, this person is placing my son in harm's way. The evidence, I have videos, photographs, the whole 9 yards. The person lost their child, their parental rights to a child that they had 100% unabated custody of because of their conduct and the determination that they were a danger to that child. And they lost their parental rights to somebody who wasn't even biological family. It was a CPS worker, a friend of theirs that they went to school with. And that person, when they realized that this person abandoned their child and was a danger to their child, they moved in and they seized guardianship and the person never got it back. So everything that I'm suffering, that I went to go stand and fight side by side with this person for their parental rights, is now being done to me because that person, can you believe that person had their child taken by a CPS worker as their friend who they abandoned their kid with? And that CPS worker used all the money and power of their family to abolish this person's parental rights. And now this person is doing that to me when I said, hey, you're doing the same thing that they were doing. Because when they took her parental rights, they were carrying out behavior. We got pictures from the internet. We went to the ombudsman. Everything that I did, we did to protect her child. I have that in writing, right? So everything that they did, she was doing. But now she's a CPS worker. She's the one with the money. She's the one with the power. So when I sought to protect our son, like I sought to protect her son, she has now weaponized the same machineries and mechanisms that they did. But you know what the difference is? That CPS worker that took her child didn't have a child taken away from her for going out there and doing what this person did. How can Napa County, how can the state of California consistently ignore that a parent that lost their child and their parental rights unabated? It wasn't like this was a custody dispute between the biological parent. The biological parent had nothing to do with her, nothing to do with the child, just completely wanted nothing to do. So she had unrestrained parental rights and lost those. How serious does that have to be? You got a mother, biological, unrestrained, and lost it to somebody, people who are not the parents, they're not biological family? How does that happen? How severe does the circumstance have to be for that to occur, right? How severe is an individual's behavior that the court takes all of her parental rights, gives it to people who are not the biological family when she's a mother? And you know how hard it is in California and many other places to circumvent that bond and that in the courtroom. There's got to be serious. There's people who do horrible stuff and they give back their parental rights. All right, Family Code, Chapter 3.5, Attorney's Fees, Costs 2030 through 2034. In the proceeding for dissolution of marriage, okay, I think I read this over. The Judicial Council shall by January 2012 adopt statewide rule of court to implement this section and develop a form for the information that shall be submitted to the court to obtain or award attorney's fees. All right, now we're going to step into something. It gets worse, folks. All right, so victims. CHS, CI, victims, witnesses, witness. All right. So that was the first oopie doopie, right? The person in the dissolution, I filed in March of 2022. The person didn't respond until January of 2023. That's a default. You have to respond. Once you've been properly served by the opposing party in a dissolution of marriage, you have to respond within the time allotted. She didn't respond for 10 months, damn near, right? So I requested a default. Honorable Victoria Wood set my default aside. That was number one. She denied SoberLink, considering all the history, the photos, all the evidence that said, hey, there's merit to this right here. There's a potential harm to this child. Instead, she minimized it. Well, people party here and all that. Hey, I drive for those people. I drive for the people that come to Napa. They don't bring their kids with them. I'm their driver, okay? They leave the kids separate, and then they go out and they party and they have fun. I drive the limos, I drive the Bentleys, I drive the Suburbans and all that, and they don't have their kids in the car. So spare me that horse crap, man. This is Napa, so people come to party and yada, yada. I want to hear that crap, man. There's two little girls they're gone. 2 5-year-old girls in our circle of friends that are gone because the mother, we got to get turned up. And then she got behind the wheel and careened into Otay Lakes. She escaped. Her boyfriend escaped, but both their daughters didn't make it out. They're gone. So this is our circle of friends. I've buried many of my friends because of making catastrophic life choices. So it doesn't make no sense for me to ignore that in my decision making or people that are near my child that would either influence or place my child in harm's way. I don't think so. My duty is to my son, as is any parent to their child, not to our friends or not to our family members who are grown-ass adults that are making life choices. We have a duty to safeguard our children and shield them from bad life choices, whether it's ours or whether it's the people that we care about and we love that are abusing that duty that they have to not discharge that behavior that a child can emulate. And I don't want to hear it from nobody, to include a judge, to include the pathetic minimization and complacency. Oh, I can't live in fear. You can't live in fear, man. Well, let me explain why, okay? So she set aside the default. She denied me SoberLink. Then she denied me needs-based attorney's fees. So that means I had to fight this battle with no attorney. She refused me what's called in-camera review. Okay. So some of you don't know what in-camera is. In-camera is not on camera. In-camera is when you're in the courtroom, Your Honor, maybe go in camera. I made official request, Your Honor, maybe go in camera. In camera is when you and the other party go into the judge's quarters. It is not part of the record, and there has to be an exceptional reason for going in camera. So, if you are a victim, if somebody comes to your family's house and unalives your family members, if armed people and they take your family member and then they murk them and this way, well, you're a victim, right? If you were one of the family members that was there when it happened, say you're there and you're in there when they come and do this, you're a witness. If you tell officers, oh, it was a blue van, the license plate number, et cetera, blah, 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 you're now a confidential source. If you're a friend, a family member, somebody, maybe somebody's bragging about it. Maybe you work at a coffee shop and you're just minding your business, busting tables. You're like, and somebody is like, you hear two dudes over talking like, yeah, man, that was crazy, man. We went in there, we kicked in the door, and man, it was like that. Okay, and you're like, damn, that's scary. That's horrible. Oh my goodness, that sounds terrible. I overheard these people talking about what they did. And you contact law enforcement, Crime Stoppers, maybe your father's a police officer, your uncle, brother, whatever. You're now a confidential informant or a confidential human source. Confidential informants can be people who are actively engaged in sophisticated criminal conduct and they get pinched or arrested. And then they're given an opportunity to save themselves or to roll on other people to minimize downward departures, right? So there's that kind of confidential informant. There's say a neighbor knows who the people are and saw the people who went in there. Well, that's potentially a witness, or it could be a confidential informant. Say you're one of the victims. But you know who did it. Oh yeah, I know who went in there and boo-bopped and did this thing and it did. Now you're a victim and a CI. A source is potentially a CI, but a confidential human source can just be a source of information. A CI can be somebody that's potentially operational. They could be acquiring. They can be involved in the acquisition of actionable intelligence, controlled buys. They could be going out there. They do, like, say somebody did harm to a child and they get somebody to call and be like, hey, remember when, you was telling me the whoop-de-wop and the yada yada that you did this and you did that? The cold call, you know what I mean? I can't remember. It's not a controlled call. There's a term for it. That would be a CI. But if somebody busted up or smoked your family member, is it wrong for you to be, as the victim, to be a CHS or a witness? But any one of these people are supposed to be protected. They're not supposed to be forced to go. Imagine if they're like, yeah, there's a whole bunch of people right here, and we want you to tell everybody who the people that did the things and everything, and you're going to just, it's ridiculous. So going in camera under the law to protect victims, witnesses, or anything like that, that is the appropriate measure. Victoria Wood consistently denied that. She said, oh, it's a constitutional thing, yada, yada. I would later find out by the Goudreau that she went in camera with them, but they are a wealthy family. And I would other people that, yes, they do go in camera, not just anybody, but Honorable Victoria Wood. So I have to be honest, I felt some kind of way because I explained it to her like, hey, man, armed people came and took my first wife's father from his house and they unalived him and left him on the freeway right there on Palm Avenue off the 805, right? They took him from San Carlos and dumped him. He must have tried to fight for his life because he must have seen the freeway. If you have grown up in San Diego, it is. When you're on the 805 or the 5 freeway, the closer you get to the border, You see Coronado, Palm Avenue, you got like a minute. San Isidro, Once you're past that, you're gonzo. You're into Mexico, and it's curtains in a horrible way. It happens quite often in San Diego, where cartel operators send people out of Mexico, or they have operators in San Diego, and they send them in to San Diego places, and they do snatch and grabs and take people into Mexico, and then they're found dispatched. This has happened. Sometimes they don't even make it that far, and they'll find them over by the Palm Pits. Okay? So you can imagine that my first wife's father must have known if I'm going to Mexico, it's going to be brutal for me. So he must have fought. Something must have happened. That's the only thing I can assume, because they dumped him on the 805 on Palm Avenue. That'd be a weird place. And then they took his navigator and continued into probably Mexico, right? So would it be ideal? I had reached out to my first wife, and I said, hey, I need you to explain to Honorable Wood here that this is serious, man, that your family had to uproot and bounce out because these people don't play no games. And I'm sitting there in the courtroom explaining to Honorable Wood what the outcome could potentially be. The potential outcome is loss of life. And I reiterated that, and I explained to her the how and the why. So there's no excuse for the consistent denial of in-camera review. So imagine if you're a litigant and this is your circumstance. You're either a victim, a CHS, a witness, whatever. And the people who did this are still out there. They're still at large. And you go into a family court and you're like, hey, I need my son to stay out of certain places for this reason. And they're like, oh, yeah, well, just to, I had to spend an hour and some change explaining this. It compelled me to speak about all this stuff in an open courtroom. And the other opposing counsel was demanding information that's operational and protected information that they're not worthy of having. And this was allowed. Now, at the end of it, Victoria Wood made the ruling. You may not take this man's child into Mexico. So I prevailed, but at what cost? Now the opposing party, who is directly connected to the very people, and she's angry. I can't do what I want to do now. I can't take my kid into danger. And if there's anybody out there, I don't care who you are, if there's anybody that wants to argue against that, step on up. Come on. Come on. If somebody's going to take my son into cartel-controlled areas with somebody who's actively engaged in sophisticated criminal conduct for the cartels, that's 100% what happened to my first wife's father. That's why he's not here. It was him that was actively engaged in sophisticated criminal conduct. But who had to move away after he was unalived? His wife, his daughters, everybody had to move away because of his sophisticated criminal conduct. And now my son is being taken into the same areas with somebody conducting the same kind of goofosaurus stuff. And the county of Napa just wanted to look the other way. They're like, yeah, we don't. Yeah, that's judges. That's Robert Stamps. That's Joseph Solga. That's District Attorney Allison Haley. That's the Napa Sheriff, the Napa PD. They always got all these excuses. Oh, well, that doesn't happen in Napa. Well, let me tell you where it does happen, Allison Haley of the Napa District Attorney. It happens in San Diego. It happens in, wait a second, it happens in Los Angeles, where you worked for DHS in LA. It happens in Mexico. And I've had to deal with their minimization and their complacency from the outset. So you can see the videos where I went. We had to get creative in 2024. If you go to the media, they don't help. I hate to say it. How many people are out there and they're like, why does the media help me? So we had to get creative. So we invited them to San Francisco to meet us there at the federal building, which in San Francisco, you have the federal building and you have the state building. And this state building is the Commission for Judicial Performance. It is the DOJ office, which there's nobody there, ironically, maybe one one or two. There is the Court of Appeals, and there's several other things in the state building. And on this side is the federal building. It's the federal court, the FBI office is there, DEA, yada, yada, yada. And so we went there. We invited Napa County to include all the people that were complacent and saying that, oh man, this guy's overthinking it. But something that happened before that hearing was that I went to the Napa DA's office and I sat down with the so-called victims advocate of the Napa County District Attorney's Office. But she's a friend of the person who was placing my son and continues to place my son in harm's way from Napa County. They were former co-workers from the nonprofit that I've spoke about, but they both now work for the county. And she worked for the DA's office, and she was tasked with reaching out to the people who could validate the information so that I wouldn't have to say this stuff in open court. That if you're not going to go in camera, I had to get creative with going to the DA, to the Napa District Attorney's Office, Alejandra, Mendieta, I can't remember the name. She is the DA office's victims' rights advocate. And I have it in writing that I gave her the contact information of the person that validated this narrative to the Veterans Department. Because in 2010, I had to go through significant decompression and PTSD treatment with the Veterans Administration up in Santa Rosa. That's how I got the PTSD diagnosis. You don't pick up the torch and run towards Valhalla and don't have a consequence related to that. Mental stress, otherwise, right? You don't volunteer as one of the victims to be one of these. No. People volunteer for that, okay? Very rarely. But I made a bad choice. I was letting the survivor guilt of my friends that deployed, the fact that we were peacekeepers, that we went to another country to go protect people and arrest people that took human life. And man, it felt so good, man. I almost want to say it's addictive. That feeling that you have when you go and you protect human life and you walk away like, damn, I just did something significant on a global scale here. Imagine if you were able to go to Rwanda or to Monrovia or Sierra Leone and protect people that were subjected to the worst things in those circumstances, man. That's what ethnic cleansing is. When one group is like, the other group got to go. And the most horrible things will happen under those terms. So imagine you go deploy, you rock that US flag on your arm. You're rocking it, the US flag for NATO. And you're standing on business. If you've never rocked an M240 Bravo and some sappy plates, some Ranger armor, and you're out there running and doing the thing, you're going up in the bird, you come chalk one, okay? If you've never done that, it's hard to explain that feeling. So I understand when I see people go do, they're like, why are they going to Ukraine? Why are those guys going to Ukraine? I mean, it doesn't make any sense. I'll bet you it's because they want to feel important again, because they've done things that we cannot fathom. So they want to go feel that feeling again, man. But unfortunately, as a result, it puts them into like, look, they're in Ukraine and some of them are not doing so well because, some of them have passed away. I've met people. I've driven here in the DMV for somebody who was just a volunteer, not even ex-military. He volunteered and he went to go part of the volunteer forces or whatever. And he was impacted. You can tell. Right. So if people ask, well, why would anybody go put themselves in harm's way? It's that feeling of importance that like, man, because you can stand in any room. You can walk into a room full of millionaires, the most prettiest people you can see, you could be a man and walk into a room. The most handsome fella in the room could be there. The most wealthiest person in the room could be there. The most intelligent person can be there. But these dudes who have walked as giants have done things that other men cannot fathom. They can walk in that room and feel confident and self-actualized. And I've seen this, that those The most handsome person, the most wealthy person, the most intelligent person would actually gravitate towards that person and lift them up. And not in every circumstance, but in some circumstances, because that person has walked as a giant. So, me being rich, if this person ran up into a building to save and drag somebody to save them, to carry a child away from danger, you know what I mean? All the money in the world is like, you want to shake that person's hand. You want to emulate that. Like, dang, tell me what it was like. So these dudes that have walked as giants can walk into any room and they're self-actualized. They're confident. They're like, yeah, but some of them are hurt. So if it begs the question, who the heck would volunteer to go after some of the most dangerous people? I suffered. Nobody protected me. I went to foster care, group homes, to gladiator school, California Conservation Corps, the Job Corps, and then my friend who we used to run the streets for real out there, going into Mexico, partying. He said, let's join the army together. And so I joined the army with him. We joined as infantrymen. He was sent to Fort Wainwright, Alaska. He went before I did. And I was sent to Germany, to Vilseck. Shout out to Vilseck, Germany. Geht's los. Ich liebe Deutschland. And I deployed first as a peacekeeper. He would deploy after to Iraq. And he would go to combat. I would serve as a peacekeeper. He would, after leaving the army, he would join the Riverside County Sheriff's Department and worked his way up to sergeant, the tactical, like the gang unit. And so the bar was set high, man. The guy that I joined the army with, he continued on. And I wanted to do something. And I lost a lot of friends. So I made the choice to do that. I'm thinking, I was sitting there and I was watching this video on YouTube, and it's a scroll, and it talks about all the people that passed away from Big Red 1, from the 1st Infantry Division. And so I saw all my friends, and then I saw one of my friends that I didn't know passed, one of my closest friends. I hadn't heard from him in years. Then I knew why. So that was the day after watching the video and shedding my tears. I sat on the couch in Napa, California, and I made the phone call, said, put me in the fight. They gave me a set of instructions to travel from Napa to San Diego, and I did. And I sat down with DEA cold case homicide, an amazing dude, man. And it began. So if people ask why, what was the purpose, what was the intent? But none of that matters relative to the danger. People don't care why you did something or whatever. In the eyes of some people, it don't matter if I'm one of the people who was on their side of the fence or this side of the fence. But like my friend, he joined the army, joined the sheriff's department. He was a gang sergeant, for the Riverside Sheriffs. I don't think that he would be targeted for that, because it's reasonable for people to expect. If you're involved in criminality, you got to expect that people that are law enforcement, you're in opposition of one another. So it's not realistic for, like, police are going to understand that people that are committing crimes are not going to like them, and criminals are not going to like law enforcement. It's reasonable. But for the Napa County law enforcement, and I'm not saying all of them, I'm just saying I went to them, sat down with two different sets of Napa County sheriffs, sat on the phone with them. You can now see, I've told you guys that I went to the FBI building in San Francisco. I sat down in a room just like this with two drug enforcement agents, special agents for the FBI, a duty officer for the FBI in San Francisco, two DEA agents in San Francisco, then another two DEA agents on a separate occasion, talked on the phone to the agent that I mentioned. I filed an official complaint to the FBI, and I was contacted by that agent. And I didn't safeguard the number, but he had given me a means to communicate, because I told him, he thought that I let him know that I told the DA's office that, like, hey man, something ain't right, it ain't gonna work out. You guys, hey. And he said, well, add me to the emails. And I was corresponding with then Chief Investigator Leslie Patty, who has since retired. And she alleges that she reached out to the FBI on my behalf. Now, Why that's important is because when I explained to him that, no, I don't trust the DA, I have concerns that they will retaliate, he gave me a separate email. And so I forwarded him everything. And I'm not trying to say he did anything wrong at all. I'm just trying to explain to everybody the significance of what transpired. And so when I came back, it was relative to that. So my part in the unresolved unaliving of somebody, being my first wife's father, was that I volunteered. I signed a contract. That contract says you have to be polygraphed if you're ever called into question. You cannot put other people's lives in harm's way. We will not put your life in harm's way. You may not break the law, yada, 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 yada. So I have volunteered consistently to be polygraphed in the circumstance, even as lately to the DOJ in Washington, D.C. If my credibility is to be challenged, I willfully volunteer to be polygraphed. And a lot of people will argue polygraphs are not admissible as evidence. Don't kid yourself. When people go to join law enforcement, they polygraph them. They have to pass multiple polygraphs. If they fail, they don't become law enforcement. And polygraphs, if you look back at the case from Mare Island, the Vallejo Police Department, there was an FBI agent that came and polygraphed the boyfriend of the girl who had been sequestered, and they alleged that he had failed the polygraph when he had passed it with flying colors. And it turned into this whole thing where the city of Vallejo actually sued them and were charging them. That girl was taken from Mare Island Naval Shipyard by this guy who they would later find out was like an immigration or attorney from Lake Tahoe. He was a former Marine, and he did take this lady from Mare Island Naval Shipyard. And there was multiple reports about concerns. And so when she was able to escape in Los Angeles and get away, she was later accused of staging this whole thing. And they accused the boyfriend, and he was polygraphed, and it would later come out that he passed that polygraph exceptionally, but he was lied to and told that he failed it miserably as an attempt to try to get him to admit things that he did not do. Like, what? I failed it? And so that all came out in the wash, right? So some people will argue that, polygraphs are not admissible as evidence. It's not intended to be admitted as evidence. It's intended. I'm sorry if I can't see your comments. It's too far away, but thank you for the likes. I appreciate it. The polygraph is intended to establish credibility of the person. So if you sign up as this or this, it's in your contract, right? And I'm sure it's like that for the intelligence agencies, for the NSA. I'm sure they got a more effective one. Some of you may remember when they would go to vet contractors, like people that were locals in Iraq and Afghanistan, they would polygraph them. But the polygraph, do you guys know about the polygraph machine? It was invented a long time ago. And a lot of people have challenged the effectiveness of the polygraph machine. But the people who benefit and have the patent or something, they have a lot of power, and they've made sure that it stays in place. Thank you for the roses. Look into that about the polygraph and who made sure that the polygraph, being the less effective means, stayed in place when they found a more effective one, and they wanted to implement that. Because imagine you're out there in combat running around, and you have people that are locals, and they're going to be behind you with the weapon system, and you got to trust them with your life and hope that they don't, get you in the back. So people who were in that circumstance, the people in the green, wanted to make sure that these people were vetted with something more effective than a polygraph. And this came out as a conflict. Like, they wanted to use this method because it was more effective than the polygraph. But the people that had power, the people that benefited from the polygraph being the thing that's left in place, made sure that it stayed in place, right? But nevertheless, the polygraph is still used to establish credibility by law enforcement. So if there's two parties and one is saying X and the other is saying Y, it's reasonable. I've been volunteering left and right. Like, polygraph me. Come on, give me the polygraph. Come on, let's go. You can hear me in my videos where I'm like, hey, let's go. Let's go to where if either one of us is lying, there's consequences. But Allison Haley, Becky Craig, Alfredo Laranaga, and all the other people they went to great lengths to make sure that's not the case, because they know what it is. If they go in there and they lie to the feds and it gets proven, that's a whole new crime within itself. So they want to keep it in their little sandbox so they can control, and they're angry at me because I can prove that they're lying. And they're hostile and they're angry and they're clamping down even further. So they're going to make sure at some point that I come to some kind of ugly demise. But think about how easy that is. There's this, and there's this. Well, what does that mean? Is that you could potentially be targeted, right? All they have to do is put you into proximity of the people who your would-be dispatchers. And so Allison Haley, the Napa County District Attorney, has manufactured this narrative with the help of this person to conceal the connection between that person and the people who did all the harm, right? And I've been cataloging everything from the outset. And so now it's in DC, it's been there. And so a judge in DC has an opportunity to look at the evidence and be like, there's more to this. It's obvious. That's why I bring up the Family Code 2030. I can go layer for layer for layer for layer. It's not just one reversible error per se. It's not just one structural error. It's one after the other, after the other, after the other. And that is an indicator of malfeasance. If it was just like a, inadvertent mistake, these are clear. I mean, it's codified law. And to violate confidential human source protections, it's a violation of an act of Congress, right? Where's that email at? Let me read you. So you guys saw the video. You saw me at the FBI building in San Francisco. So clearly I'm not making this crap up. I just make up that I went there and yada, yada. But here's the email, or one of them. And this is on March 24th of 2024. This is the day before they went in there and took my son away. I followed through with my request for judicial review in San Francisco. None of this makes any sense that I had to go and expose myself just to get to them to protect my son. If I had a bad feeling that they would try to pull something funky. I have been nonviolent since the start of this. This is to the FBI agent that I was seeking to speak to that day. I have been nonviolent since the start of this, but they need to paint a different image. Tomorrow, yet again, I have to go into the courtroom and more than likely expose myself, just to request that the judge deny her ability to take my son down into harm's way. I filed for a restraining order as I was instructed to do by law enforcement is the best path of recourse, and she filed one in response. Despite having no evidence, they approved hers in part and denied hers in part, but completely denied mine. I always film when I'm protesting or doing anything relative to this matter, because what I've experienced from the start is that they will change the narrative or say that I said something that I did not. So I've always been live when I go into these public areas for good reason. I went and interviewed with 2 DEA agents at the office in San Francisco, as I mentioned, and asked for their help since they were the first agency that I was tasked to do. It was brought to my attention through this court hearing that we're about to have that the district attorney's office has been communicating with my spouse, and that I asked to look into her threats towards me. So the very department that I asked to question her about threatening my life, it seems has been working to try to paint me in a violent picture. I was live filming when I was protesting about what happened on February 20th in courtroom 6. On February 20th, that's when the judge that's in the saddle right now trying to destroy me, that's Robert R. Stamps. That was the day, having cleared the courtroom on January 25th, 2023, which is in the minutes, which he would later lie to Judge Cynthia Pillsbury Smith saying that the courtroom was empty. That's a bull-faced lie. It says it right there in the minutes that he had the deputy clear the courtroom. So if the courtroom was clear, how did he have the deputy clear the courtroom? It's ridiculous. And Cynthia Pillsbury Smith, she was just like, it's the game they play, right? So Robert Stamps on February 20th, 2024, on the hearing for my restraining order, only asking that I not be compelled to surrender my location to this individual who made threats to relay that information and my service to the United States Department of Justice to her little buddies and people. That was the threat that she made. And that's a full issue to the FBI, right? So if you threaten people, victims, witnesses, whatever, that's a federal. And that's the purview and the duty of the ministerial duty of them to investigate, right? So Robert Stamps on February 20th, yet again cleared the courtroom and said, this is publication, just like Victoria Wood did, right? Just like Joseph Solga, and just like the rest, Kesha Lind as well. So on February 20th, in a courtroom full of people, I had to say all this stupid stuff. And I was like, do you not remember the contents of the sidebar that we had on January 25th of 2023? And Robert Stamps is livid right now because everything is provable that he then lied to Cynthia Pillsbury Smith, which was the presiding chief judge at the time, who investigated it, and he lied to her. And you know what? If a judge is investigated and they lie to the investigators, that's grounds for removal from the bench. And so Robert Stamps is furious right now. So February 20th in courtroom 6, but they tried to make it seem as if I was not clear as to what I meant. But you can see in the video that I said I will go to the library, type a complaint, and fax the request over to the Commission for Judicial Performance for judicial review. I am relatively safe enough for the best part that I can think in Lake Berryessa, but I'm still putting my plan together to be able to move. This restraining order was not indicated to me by an attorney as, the restraining order was what was indicated to me by an attorney as necessary. So an attorney out of Roner Park was like, yeah, you're probably going to want to get a restraining order because if you're co-parenting, you have to tell the person where you live. And if the person is directly connected to the people, you know what I mean? It's not a good idea, especially when they stacked almost $1 million of life insurance on you. Because the law states I have to tell her where I move since we are co-parenting. My only request was that she remove herself from any of my devices that I own and have tracking capability because of the software that she put into my son's devices that I own. And also that I not be required to tell her where I move once I do. They came back with an entirely elaborate scheme, and Napa County is helping them. That's Napa County District Attorney Allison Haley. That's Laura Noga, Kendall Barron, and that's when it comes into play with the PC 1368, the violation of jurisdiction, segueing over it from one jurisdiction into another improperly by falsely predicating a TRO as a CPO, a defective TRO. You know who signed off on that TRO? Robert Stamps. Yeah. It's the same people every single time. And right now they're pissed off and they're furious because I can prove that there's suborned fraud on the court because they are officers of the court. And when they do that, they betray the machinery of justice and it vitiates their rulings. If you're a judge, if you're an attorney, if you're a clerk and you're betraying the machinery of justice, if you're lying, you are breaking that very machinery that you've sworn to protect. So that's the significance of these attorneys that are playing games with the PC 1368 protocol. It's mandatory too. It's a must and a shall, and they've turned it into a weapon in the county of Napa. Imagine you're an attorney that's supposed to protect you, says, hey, just pretend that you're crazy and I'll get you off. That's what Sam Nguyen does. Sam Nguyen tries to foolishly tell people to lie to the court and say that they are insane so that he can get them off. But he has no intentions of doing that. Imagine Sang Nguyen is your attorney and says, hey, just play crazy, I'll get you off. And then you go do it and they determine that you are. And then Sang Nguyen is in full control of you because you just help him put all the controls in place that he needs. Should attorneys be telling their clients, advising their clients to pretend that they're insane? No. I would humbly ask that they be looked into for their actions as well as her. It never made any sense to me that I've been going to them since the beginning and they have done absolutely nothing. I've never asked for them to prosecute her. I've asked for them to make a record of what has happened. If you're available tomorrow, court is 9 a.m. Here's the case number in courtroom C. And then it goes on further. So, I don't lie. When you're trying to protect the life of your child, you have to be brutally honest. And that's what I did when I went before Honorable Victoria Wood. I was always brutally honest. I always told the truth. And my expectation was that that would mean for something. Because if she determined that I was lying when I'm trying to protect my son, she would potentially rule against me. But she ruled in my favor to an extent. But her denial of needs-based attorney's fees has set off this chain of events that's before the state Supreme Court, it's before the Court of Appeals, all this. But the Court of Appeals signed off on that. And CRC, California Rules of Court, Rule 8.115, subsection A, prohibits courts and parties from citing or relying on opinions not certified for publication or ordered published, except as specified by Rule 81115, subsection B. This opinion has not been certified for publication or ordered published for the purposes of Rule 8.115. Yet, Robert Stamps and others keep using this in DC. In Washington, D.C., the attorney for the DOJ, he cited this to seek to validate or support his premise that, oh, yeah, the Court of Appeals signed off on all that. Like, yeah, they agreed with the lower court. Anybody can run this unpublished opinion that he's not supposed to be citing to begin with. You can't validate a legal argument with an unpublished opinion in accordance with this rule. But in the county of Napa, they consistently lean on this to validate their harm that they've done. And that's what happens. Unfortunately, people go in, and once a ruling is in place, man, that gear don't go in. Like, you have a standard car back in the day, and you try to go in reverse or first gear, and you got to like stick your leg out the car and go and get it started and jump into second gear, or just start in second gear. Because when you try to go into first, it's like, well, that's how some of these rulings are. Once they go one way, they don't go the other, because then that could detrimentally impact their career. So no matter what, they're going to move forward. They don't go in reverse. So when it gets to the Court of Appeals, if the Court of Appeals gives them deference by doing things like ignoring a de novo standard of review, if it's a de novo standard of review, the appellate court has to act like as if you never even had a trial down there, because the lower court violated the statutory language of the law, which in this case, Honorable Victoria Wood created her own version of the law. That's a de novo standard of review, 100%. If a judge does not read and translate the law, but instead rewrites their own law, that is legislating from the bench, and that should be at least considered to be a violation of the Separation of Powers Act. Executive, legislative, judicial, right? So using unpublished opinions to validate the lower court's premise, that's why when you're like, hey, this is a de novo standard of review, well, no, we're going to go ahead and call this abuse of discretion, because in order for it to be abuse of discretion or insufficient evidence, it's a mountain you have to climb. And even then, they're more likely to give deference to the lower court. not when it's a de novo standard of review. Just like in Remarriage of Knox 2022, which is the controlling precedent relative to Family Code 2030 Pendente Lite. Her case is spot on. Dawson Bear Knox, like mine. The variables are the same. And she achieved a reversal. So reading the Court of Appeals, you can take an opening brief, my initial appellate brief, the responsive brief, my response to the responsive to the appellate's brief. Then you can take oral arguments, their tentative opinion, and then their final opinion, and you can run it through any AI, and it'll tell you that, they completely got it wrong. They invalidate their own premises in their tentative opinion. So the judge in DC, the response by the DOJ's attorney, who the DOJ right now is represented by like 4 or 5 attorneys. So I haven't seen that in other people's cases. It's usually one attorney. The DOJ in my case has 5 attorneys. And so I was like, dang, what's going on here? And my action is a writ of mandamus, not preferred as an intent to be adversarial or to ask for money or anything. I'm asking for a ministerial duty to be performed and for them to use their compulsory power, their investigative tools, because the people over here, so we're talking about DC, right? So you got DC, we got Virginia. We got Napa. Right? All right, we got the FBI. So in Napa, California, one of the people in this evidence that I went to, as instructed by Senator Dodd, his office. It wasn't Senator Dodd. I don't have no beef with Senator Dodd or nothing. I went to his office because I was at the IRS in Santa Rosa, and I saw his office there. Matter of fact, it was the Labor Commission. I was at the Labor Commission. And they were the ones who told me, after hearing all the variables, that you need to go to your county supervisor, which is Alfredo Pedroza at the time. He's no longer a county supervisor. But who's Alfredo Pedroza? What was the subject of the FBI investigation, right? So I'm instructed to go to somebody who's under FBI investigation, who's under wiretap, right? By who? By the DOJ, by the FBI, right? And in this case, there's people that were subjects or people of interest, one of which who took their own life. Here in Napa, Ryan Clovis. Who's Ryan Clovis? He's the CEO of, or was the CEO of the Farm Bureau, right? He gets a subpoena from the DOJ, from the FBI, that we're going to need some evidence. But just days before he gets the subpoena, he takes the evidence that they would ask for after the fact to a party. Who travels to parties with evidence? You know what I mean? Hey, what's up, man? I showed up. I got some finger food. I brought a case of beer, and I got my evidence. Nobody does that. So one would think that somebody tipped him off, because then days later he gets the subpoena from the FBI for exactly what supposedly vanished at this party that Ryan Clovis goes to. Ryan Clovis is the CEO of the Farm Bureau, and not long thereafter he dispatches himself. So you got people dispatching themselves. You got the FBI, you got the DOJ, Napa County, all these people. You have a grand jury in where? San Francisco. So there's a case in DC, my case. And the response from the DOJ's attorney is that, oh man, this is just some conspiratorial stuff. Look, if the FBI wasn't investigating these people in Napa, if dude didn't unalive himself, if there wasn't wiretap authorized by a federal judge, I could see that. And I've said that from the outset. That would be, it's an ideal circumstance for people that are navigating a battle like this, that you're like, hey, there's something going on here. There's potential for corruption, you start whistleblowing, and they're already investigating the people that you're like, that should be a help, not a hindrance. So when I read what the DOJ attorney did in DC, I was taken aback, reasonably, right? I was thinking, like, what is this dude talking about, man? Somebody took their life over here in this circumstance, and they're being investigated, wiretapped, and all that stuff right here. So that doesn't make any sense. You're rhetorically manufacturing something in my mind. FBI was investigating the county of Napa. They went and bum rushed dude's house, spent, I think, 6 hours there or something like that. They had him on a wiretap, and he was my county supervisor who I went to and sat down with his direct report and was like, hey, man, my son's being taken into some really unfavorable conditions. And instead, all of those people, which would lead to Mike Thompson. The case in Washington, D.C. against Congressman Mike Thompson and his direct reports. Because before I went into that hearing with Victoria Wood, where she refused to allow me to go to camera yet again, and I spent an hour explaining all this insane stuff in front of the very person who threatened to relay that to all these unsavory people, which is a federal offense to do, falls within the purview of the FBI, right? Right. So before that hearing, I sat down with the Napa district attorney, the victim's advocate. She said that she was reaching out to San Diego, to the very people who the Veterans Administration had to reach out to in 2010, because the Veterans Administration had to treat me, to be like, they had to make sure, is this dude really for real? And they validated it. So then my treatment began. They gave me a service animal, medication for nightmares and all that. I'm not a combat veteran, man. I'm just a guy. I'm a peacekeeper. Mike Thompson is a combat veteran. So it's a tragedy that a combat veteran would try to frame a nonviolent, peaceful peacekeeper as a harm or a danger in order to conceal the fact that he reached out from Napa to the DOJ on my behalf for a congressional request for, hold on, my battery is getting low here. Let me see here. Stand by, wait one, folks. I got to get power to my phone before she dies. So Congressman Mike Thompson initiated a congressional inquiry, which is his duty to do, on my behalf. And so once he initiated that congressional inquiry, once I signed a release, he had a duty, which he alleges he initiated, which was a request from Napa to Washington, D.C., to the U.S. Attorney's Office for a situation report request to the FBI, right? So he says that he completed that. But before I went into the hearing in 2023, I sat down with the district attorney's office and I sat down with Congressman Mike Thompson's staff and explained, as well as the state representative, which is, what's her name? Aguilar, oh God. It escapes me right now. The bandwidth is stretched thin, if you know what I mean. Aguilar Curry. So I asked them to do something, to reach out and to help, so I wouldn't be compelled to go into a courtroom and say all this stuff. And he failed to do anything, completely dropped the ball. So in 2023, when I had to go into that courtroom and do all this stuff to protect my kid, and Victoria Wood put an order in place that prohibits my son from traveling into the area of operations controlled by the people who took the life of my first wife's father, which should be a reasonable request, right? To not be allowed to travel into Mexico with a person who was actively engaged in sophisticated criminal conduct for the same people? This just sounds like bananas and nuts, man, that I even have to go through all this stuff. But I went to Congressman Mike Thompson before that. And then when I had to go in there and do all this stuff, then I sought an accountability. And Luca, one of the defendants, one of his direct reports, sent me all the documentation. You can see it, that like initiated a congressional inquiry. That's when the duty and the mandates kicked in. And so if Congressman Mike Thompson alleges that he sent a request for a situation report to the DOJ would have that information. So it wouldn't be that hard for them to validate it to the court in DC to be like, hey, either we got it and we didn't do anything with it, or we never got it, meaning the congressman did it. And the congressman has not responded to the allegations. They have not defended at all, ironically. So who didn't do something? So my request to the DOJ is reasonable. It's like, hey, man, did this person do this task? Did this person fail a duty to protect my kid? And then did they try to mischaracterize me, a peacekeeper for NATO, as a dangerous combat veteran when I didn't go to combat? I was a peacekeeper for NATO. I went and saved human lives, protected. He went to combat. He was in Vietnam. He's a Purple Heart recipient. Imagine if the adverse. So he should know that how that would feel as a Vietnam veteran to come back and people were treating them like dog. The Vietnam veterans, Swords and Plowshares, and all those other groups, man, those are our big brothers that fought to make sure that other people don't get dogged out. So for Mike Thompson, who is actually a combat veteran, to do that to me, it's bizarre. It's confusing, one could say. So that too is a violation of his duty and his commitment to the veteran community, that he would, a father who didn't go to combat, who volunteers to go be in harm's way because other people that he went to go protect human life with did go to combat and many lost their lives. He volunteers to go do something dangerous, and then later would go to combat veteran Mike Thompson to ask that, hey, can you protect my child? So a combat veteran is going to understand if somebody volunteers to go into danger, he'll understand that because he has been a selfless person himself. I mean, I don't know if he was compelled or if he volunteered or what, but he's going to know valor. He has seen valor. He's a Purple Heart recipient. So for him to willfully, intentionally mischaracterize anything and to commit fraud and perjury and to do all that, it's reasonable that the DOJ here or somebody should answer, did he ever complete that task? And his unwillingness to surrender the findings or respond to a federal action that has been preferred against him in DC for what happened on February 13, 2026 at the Cannon Building in Washington, DC, it's another indicator of potential reckless abandon. So I'm just trying to get some answers here. But in order to get more answers, and the harder I fight because of the malicious retaliatory conduct of the county of Napa and these people who want to hide what they've done, to include the justices, the arbiters, Robert Stamps has just completely gone off the rails with his conduct, as evident at what took place last Tuesday. And yet again, lying consistently in the verbiage. So it's not just that they want to get away with stuff, but they want to lie in writing when that's an attack on the machinery of justice, as they are officers of the court, to conceal it. And if you, the person that they lie about, is able to prove it, they then get angry at you. That's bizarre, man. Like, hey, you're lying. I'm telling the truth. I can prove you're lying, and you're getting angry at me. It's like when people whistleblow, and it's ironic because Mike Thompson's up in DC right now trying to pass a whistleblower protection law when he willfully, intentionally retaliated against a whistleblower. Isn't that bizarre? That's the audacity of these people. And so whistleblower protections seem to be just like a generic term that is it's a woozy-wazy, because whistleblowers are being targeted for whistleblowing. So throughout the last few presidential, whatever controls of the country, administrations, there's been whistleblower retaliation. How many of us remember when somebody came forward with the criminal conduct or the betrayal of people. And those people, instead of saying, yeah, we did wrong, you know what, we need to step down, those people said, oh, you broke the law to prove that we broke the law. That's insanity. That's like somebody breaking, I'm going to say this again and again and again. It's my example. It's like somebody breaking into my neighbor's house and I'm filming them with a camera and they see me filming them and turn to me and say, you can't film me. I haven't given you permission to film me. You're violating my rights. You're breaking the law by filming me breaking the law. And wouldn't that be just like the most ridiculous thing you ever heard? But that's the mental status of these people who wield this power. And they are the ones that have a duty that they swore to protect the machinery and honesty and integrity and justice. Yet they betray it. But yet my friends and my brothers, they gave their lives to honor their oath. Doesn't matter the merits of why they were sent to Iraq or Afghanistan or whatever. They swore an oath. They went and complied with what they were doing, and many of them paid with their lives. Many of them made it back home, but suffer inside, outside. They honored their oath. So these people who do far less than go and fight the Taliban or Al Qaeda or anybody else, they get up there on the stand and they violate people's rights. And when people press back and say, hey, the Constitution means something, it's the supreme law of the land. And then these people target them. Shout out to Austin Bennett out there in Sacramento and the other people that stand in opposition, that say, hey, we shall not go quietly into the night. We shall non-violently, peacefully stand in opposition. We will be the rock in the stream, but that comes with consequences. Agnes Banda, her case, she's in custody and out there in Tennessee, Washington County. It's an indication, it's a validation of these parents' concerns that they set traps and they go in there and just try to fight for their rights, and then they seek to control. Her case validates that narrative that it's not a psychosis, it's not an invalidated fear, is that they use people's children as a lure to get them in there, and then it's like, bam, they're screwed. So Agnes Banda is now in custody in Tennessee, unfortunately, and she's at their mercy. And so I would say if people are going to try to help her, don't make it worse by calling and lambasting those people. Call DC, call VAWA, because she was asserting VAWA. So call Washington DC and let them know. But yeah, man, it's an uphill battle. So hey, I got to get back to work. It's been a pleasure spending some time with you guys. Napa County, I know you guys are here. More than likely the feds, you guys are here. I know them thugs are here too. So I'm going to have to present an argument to the justices here. If I'm allowed to move forward with my federal appeal to the Fourth Circuit, I've made the argument to the District Court of Appeals in San Francisco. How can justice be served? How can due process be honored if one party here, here's two party, here's the judge, right? If one party has no attorney, one party has an attorney, right? One party does not. One party has PTSD, the other does not. One party is a victim of unaliving and smidnapping, the other is not. One person was actively engaged in sophisticated criminal conduct with those same people responsible for this harm. And this judge has a duty to overhear and listen and give equitable justice. But this person has protections that this person does not have. But this person has protections from this person instead of, because this person works for these people. So in what courtroom in the land would it ever be ideal to force a victim of murder to go into a courtroom and talk about the operational information relative to that? If a victim volunteered to the DOJ to seek justice for the other victims, and goes into a courtroom, and this person was on the bad guys team. So this person on the good guys team, that person on the bad person's team, right? And then this judge is supposed to safeguard justice. But this judge allows this person to ask questions and demand information about operational conduct of this person, how and what courtroom in this country, in a family law circumstance, would that be justifiable? Right now, I'm in the Commonwealth of Virginia, which is governed by Governor Spanberger, who's former law enforcement and CIA. And the demographics and the population density of the DMV, Maryland, Virginia, DC, everything, it's saturated with people for the NSC, the FBI, the DOJ, the CIA, because of what DC is. All that stuff is here. So there's a lot more people per capita here that operate for those agencies. So those people will understand operational integrity, and I would assume that they could fathom that if they had to go into a courtroom to get divorced and fight for their custody of their children, that whatever they did for the CIA or the NSC or FBI or whomever, operational integrity, national security would not be allowed in a family court to be weaponized by their spouse against them, right? In what court in the land would that be tolerated? Begs the question, right? That's my argument. Is there a justice that would, and I made that argument to the First District Court of Appeals in San Francisco. If you're saying that person A can operate undercover and person B can have been arrested for operating with the people that this person, no LICO, no work, interest. How could this person enter into a family courtroom and this person's entitled to an attorney but not given one? This person has the money for an attorney, works for the county, testifies for the court and these judges, and then these judges allow that person to demand information from this person that could lead to loss of life, that violates operational integrity, that's protected. When this person threatened to relay that person to, let's call to these people. So this person threatens to hand the information about this person to these people. This person alerts the DOJ, alerts the people who have a duty. They do whatever they do. Then this person enters into a courtroom and has their attorney demand that information from this person, and this person lets it happen. The judge, that would be Victoria Wood, because she has a duty to safeguard those measures of protection. I outlined it verbatim for her, what could happen by what she's doing. So there's no excuse to be like, oh, I didn't know, because I told her in great detail that if you allow them to do this, this is the potential for harm. And that's why I went to Congressman Mike Thompson's office. That's why I went to State Representative Aguilar Curry. I went to Napa County District Attorney. But like I said, these people are all friends, right? The guy that was under the FBI investigation, he's friends with Mike Thompson. The women that are married to the people connected to these people, they work with the nonprofits that Mike Thompson and the other people work with, as did this person. She worked at the nonprofit with these other women who are all married to these members of organized crime. I have no desire or justifiable reason to hang with people who are connected to organized crime, because I operated for the DOJ against organized crime. And so it should be reasonable for me to expect judges, not just judges, justices who were the next level of a judge, who were prosecutors against these people before they were judges. It shouldn't be difficult for me to have an expectation of an arbiter who has operated against these people in a judicial capacity. For me, as somebody who operated in an operational capacity here, for them to safeguard and prevent this person from doing exactly what they did, as cited in my appellate brief, in my responsive brief, in my writ of certiorari to the United States Supreme Court 42 USC 1983 civil RICO that is now before the Fourth Circuit Court of Appeals. So now it will fall to the justices of the Fourth Circuit Court of Appeals to step back and be like, does the merits of this guy's argument make sense? And I have to express disappointment because and only because the judge, the federal arbiter, was a former prosecutor against these kind of people. And so having seen over 1,000 pages of evidence submitted into the record, and me saying, hey, maybe go in camera so I can provide a limited scope discovery, let them hear the defendants, the county of Napa, in their own words on audio that was achieved by a public records request. It's their own audio, so it is admissible as evidence entirely. Let them hear it. But I was denied. And I'm not trying to cast aspersions on the individual, but I was shocked, man. I was a bit taken aback. You know, that like, hey, the referee operated against these people. This person operated in the capacity, right? This person was supposed to. That person worked in the capacity along these lines as a DOJ or a BOP subcontractor. And instead, that person betrayed that and hooked up with these people. And so this person is supposed to protect this person's rights against this kind of conduct. And this person, to conceal their conduct, threatens this person to relay the information here. So this person should know reasonably as a former prosecutor who targeted international or transnational groups and prosecuted them careerly before being a judge. I was elated when I found that out, when I did my research, and I was like, oh man, so all the evidence that I'm submitting, they're gonna know what it is, where a white collar crime judge or attorney or defense attorney, because some people are AUSAs, some people were prosecutors, some people were defenders. But if they're in that realm of defending or prosecuting organized crime or people who are that caliber, they're gonna know, they're gonna be like, yeah, he's right. If we were in court and this would never be allowed in federal court. So why are they doing this down here at the Superior Court, which is an inferior court? And I'm not trying to it's inferior in the sense that Superior, Appellate, Supreme Court of the state, United States Supreme Court. So why would in federal court this not be allowed, but it's being circumvented in a Superior Court down here? So they would understand what 19 CFR 16.15 and all those things are. They're going to understand the case law because they have to do these things. They have to put things under seal. They have to go in camera. You got grand juries, all that. They understand the importance of operational integrity. Whereas some people who don't operate in that capacity, it's like a foreign object to them. What is that? I don't understand that. What is that? But when you go into an arena and you're like, oh man, this person's going to understand. And then you provide DOJ reports, communications between you and agents and yada, yada. And then someone says that they have concerns, grave concerns as to the merits of the argument. That's an alarming indication. And I'm not saying nothing bad, but it makes me wonder why. Like what? How? What? How? How could that be? So I had to go to the next step. You have to win. You have to lose to win. Unfortunately, in some circumstances, you have to lose in one place to ask to go to the next step. And so right now there's multiple mandamus and writs of prohibition that are parked before the Fourth District Court of Appeal. And I'll be honest, I just hope that they take a look and step back and be like, you know what? Maybe we screwed up on this. But I don't know if that's going to happen because they've already done some horrible stuff, which is their unpublished opinion that has been weaponized despite it saying right there on the top that they may not. And this unpublished opinion is saturated with defects and just straight falsehoods. So having you can hear me at oral arguments. I said, hey, you on the right and the left, if you're A and this is person, I mean, I walked them through it. But now I have to make this argument before federal court justices. But the irony is that the first court of appeals is the presiding judge is a former U.S. attorney who prosecuted white collar crimes. But I asked them, I said, did you guys just white collar, family, criminal? And they, what kind of law are you guys specialized in? They said, we see it all. But the presiding judge is a former U.S. attorney who knows about this kind of stuff. You know what I mean? So the fact that what she wrote and what she did, despite all the evidence, despite the lack of a statement of decisions, and I pointed that out, that's a reversible error. It is. It is. The rebuttable presumption, Family Code 3044, the needs-based attorney fees, Family Code 2030, pendente lite, in remarriage of Knox, 2022. Listen, you can hear me cite it. It's a reversible error. It's the controlling precedent. And to ignore that, and then to falsely state that it's time barred when Dawson Bear Knox, didn't appeal until 3 years after, right? At the end of everything. But in Dawson, they did the same thing to Dawson Knox. She made the request, so it initiates the mandate. They ignored it and told her, you can wait till later. Why does that sound so familiar? Isn't that what Victoria Wood said in her ruling? Victoria Wood rewrote law from the bench. You don't even got to be in to do that. Who writes the law? The legislators. The judges are to enforce it. And the legislative intent was a removal of the discretion from the judges to ensure they put in guardrails to make sure that people's rights aren't abridged. And the judge rewrote the law and removed the guardrails. And the Court of Appeals is supposed to be like, yeah, no, this is de novo standard of review. She got it wrong. We have to reverse this. And instead, the Court of Appeals gives me this horse caca right here. So unfortunately, that's a bad indication. And that's what Austin Bennett's saying over there in Sacramento. But I've submitted writs of mandamus, writs of prohibition to the same court and to the Supreme Court with the humble hope that they'll look at it and be like, you know what? This guy's not just trying to get one over, because that was their assertion, was that I was trying to use a technicality. What? Man, you crazy, man? I was taken aback. It does not matter. There was a guy on trial for he smoked 3 people, man. I can't remember the case, something, Missouri, Louisiana. He was caught 3 states over with the weapon, with DNA, all kinds of stuff. And because the attorney got it wrong, that case was overturned. It was a structural error because he kept saying he was innocent, and his attorney at the trial was saying that he wasn't, and that he tried to separate from his attorney. And because his attorney, during the trial, when he was jumping out saying, I am innocent, even though he was guilty, it was all obvious, the attorney did not have that right to do so. But the attorney thought he was doing what was in his client's best interest, but it didn't matter because the man said he was innocent, and he had a constitutional right to say that. So as a result of that attorney's mistake, that those victims, the case got overturned. That's horrible. I'm not trying to do that, man. But the fact that the First District Court of Appeals would even make that implication with all the evidence, when one parent, who they conveniently like to leave that out, had their parental rights abolished because of their criminal action. That wasn't me. That was somebody else on the other side. And they strategically left all of that out of there. They just said, oh, he says that she threatened him. They didn't say that, oh, she threatened him, or that he says that she threatened him and he went to the FBI and he made the official complaints. That she was arrested with the very, you know what I'm saying? They left all of that out, but it was right there in front of them. But in here, in this unpublished opinion, it's horrible. And then the lower court, and then you got in DC, you got the DC DOJ attorney, and then you got Robert Stamps over here in Napa, both using this when it's an unpublished opinion. And what does it say right here? California Rules 8.115 subsection A prohibits courts and parties from citing or relying on an opinion not certified for publication, which this one is. But they consistently violate this. And they, like I read it. It's in English. Is that in English? Did I read it in, was it Aramaic that I just read? No, I read English. And I keep citing it. Like, why are you citing an unpublished opinion when it says that you can't? Oh, well, Fuzzy Wuzzy was a bear. Man, get off the gas, man. It's a dirty bar fight in the alley down there, man. And they're hitting you below the belt. They're pulling hair. Yeah, man. So when parents step out there and they're saying that they're being just decimated in these courtrooms, man, they're not exaggerating. So this is what it takes right here: a room full of documentation, and you're going to stretch your bandwidth to its limits, and then you're going to exceed those limits. But there's nothing more ideal or honorable a fight to have than for the protection of your child. So here we are. I got to get back to work, y'all.